take your job, destroy your marriage. I will make you suffer, I will make you pay. For every second, for every hour, for every single day. I live without my children, will take all of your money by filing lawsuit after lawsuit. In your individual capacity, you are liable to me. I will make sure you pay your crimes with big compassion until my dying day. Everyone will know you enjoy hurting children while you are at one. I will make you suffer, I will make you pay. I will make you suffer, I will make you pay. For every second, for every hour, for every single day. I will take your job, destroy your marriage. I will make you suffer, I will make you pay. For every second, for every hour, for I will take your job, for every single day. I will take your job, destroy your marriage. I will make you suffer, I will make you pay. For every second, for every hour, for every single day. I live without my children, I will take all of your money by filing lawsuit after lawsuit. In your individual capacity, you are liable to me. I will make sure you pay your crimes with public face until my dying day. Everyone will know you enjoy hurting children while you are at one. I will make you suffer, I will make you pay. I will make you suffer, I will make you pay. For every second, for every hour, for every single day. You are weak and defective. Rejoice hurting kids. I will make you pay for what you may until I did. You are I will take your job, destroy your marriage. I will make you suffer, I will make you pay. For every second, for every hour, for every single day. I live without my children, will take all of your money by filing lawsuit after lawsuit. In your individual capacity, you are liable to me. I will make sure you pay your crimes with big compassion until my dying day. Everyone will know you enjoy hurting children while you are at one. I will make you suffer, I will make you pay. I will make you suffer, I will make you pay. For every second, for every hour, for every single day. I will take your job, destroy your marriage. I will make you suffer, I will make you pay. For every second, for every hour, for I will take your job, for every single day.
In 1977, in the evergreen state of Washington, a pivotal piece of legislation came into effect, the Juvenile Court Act. Crafted with the intent to rehabilitate rather than punish, this act represented a forward-thinking approach to juvenile justice, targeting assistance at younger members of society who found themselves tangled in the legal system, often due to circumstances beyond their control. Originally, the act sought to provide a lifeline to runaways and homeless youth, offering them shelter and support in times of crisis with their families. These juveniles were referred to as wards of the state, a term that underscored their protective custody under the law. A significant shift came with a series of rulings by the Supreme Court of Washington. Amid increasing concerns from parents struggling to control their behaviorally challenging children, the court extended the act's reach. It allowed parents to request state intervention, facilitating access to necessary treatments and counseling services that they might not otherwise afford. The dependency of Henry Shermer, born February 7, 1990, marked another landmark development. Following this case, the court system began to allow parents to acknowledge their child's dependency while keeping them at home or in a foster home or treatment facility, supported by state-funded rehabilitation services. However, the expansion of the Juvenile Court Act into RCW 13.34 was not without its controversies, as the law became flooded with even the youngest members of society, including infants and newborns. It also increasingly served as a tool for more definitive separations between children and their biological parents. Victims of Superior Court of Washington corrupt judges claim that the act's noble intent has been overshadowed. RCW 13.34 has been used more than 300 times to manipulate parents into relinquishing their rights under the guise of dependency court orders. These orders lacked a path to reunification, trapping families in a cycle of dependency reviews without resolution. RCW 13.34 does not have any reunification statutes. In the judiciary's labyrinth, the battle between child protection and parental rights often leaves the most vulnerable in a precarious balance. The stakes are high, with children's futures hanging in the balance, controlled by a system that some say is too quick to separate rather than mend. In a shadowy corner of the system, there lurks a figure cloaked in the guise of righteousness, spending a full 40 hours each week meticulously crafting illusions. They seduce vulnerable juveniles with promises of salvation and support, yet beneath this facade, a more sinister agenda unfolds. While projecting an image of benevolence, their administration mercilessly thrusts infants into foster homes, blatantly disregarding the children's stability and familial connections. These are not dependent children lost in the system. These are infants with homes cruelly uprooted. What breed of villainy overlooks the very souls the Juvenile Court Act, specifically RCW 13.34, was designed to protect? This act, meant to shield families in turmoil, homeless adolescents, and drug-afflicted teens desperate for rehabilitation, is twisted to serve nefarious ends. Meanwhile, it grossly infringes upon the constitutional rights of single parents by wrenching them away from their newborns under the cold, misleading guise of laws intended for juvenile dependence. In a disturbing charade of familial warmth, foster parents coax tender toddlers to call them mommy and daddy, ingraining foreign beliefs and collecting substantial sums, a staggering $1,500 monthly per child in adoption assistance, continuing until the child reaches 21 years of age. All the while, these guardians of pretense are privy to the truth laid bare by RCW 13.34. A child must be demonstrably abandoned for 3 months before any petition can be legally entertained. Yet, they turn a blind eye, eagerly anticipating the day they can erase the names of biological parents from a child's birth certificate, rewriting history as if stitching together a new identity. One shudders to contemplate what sort of person can witness and comprehend the letter of the law, fully aware that it was crafted to protect abandoned children, not to facilitate opportunistic adoptions. The chilling reality continues unchallenged as each newborn, whisked away from the birthing room straight into their scheming arms, remains ignorant of their true origins, a poignant truth forever sealed, vanishing with the stroke of a pen.
So how do you know that you still have PTSD without, if you don't have...
You don't get rid of it. You don't get rid of it on your own. It's not something you get rid of. Just like bipolar, it's not something you get rid of, which is why you can't take kids for that, because it's a lifelong thing. You just can't say, oh my God, she's bipolar, let's go take her kid. It doesn't work like that. You got to have the Fourth Amendment requires, what does it require? Probable cause. Probable cause of child abuse is not bipolar disorder. It's not drug use. It's probable cause of child abuse. Proof a child has been abused. You can't take a kid for PTSD or bipolar or anything like that. It has to actually be probable cause. Fourth Amendment, the Supremacy Clause of the Washington State Constitution, it goes over everything that you guys talk about. You guys have to follow the Constitution of the United States. The Supremacy Clause says so, and so does the Supremacy Clause is actually in the Washington State Constitution, which is what you guys are bound by too. So, don't act like you don't have to follow the Constitution, you do. So you have to have proof of child abuse and neglect. You can't just take kids and say, oh my God, she's bipolar, oh my God, she's a drug addict. So what? So is half the world. We don't take all their kids because of it, seriously. Nobody would have kids if that were the case.
Okay. You said addiction is lifelong. Are you currently using any intoxicating substances?
No, I'm not.
When was your last use?
I've never used drugs in my life, ever.
Do you believe that substance use can have any impact on a person's ability to parent?
I do not.
Why not?
Unless they're making their child do drugs, then no, I don't. Unless they're like shooting needles in their arms of their child, I don't see how I just don't, unless they have to actually abuse their child for it to have an effect. I think that drug use is unfortunate and being on drugs is unfortunate, but I've seen drunk people raise kids and they grow up just fine and they're not freaking out on their parents or anything. So, I mean, it's okay when drunk people do it, and I'm pretty sure your parents had a couple drinks back in their day, but nobody took you away from, your parents. So, I mean, for them to point fingers, it really just shows that it proves racism, really, because there's no probable cause. That's what this whole case proves, is racism. There's no reason for them to take my kids, so that proves that they're racist. Of course, you guys don't see that because who knows?
Who's them?
That black lady, that's your boss.
What problems does the bipolar create for you?
I don't know, I'm not bipolar. Who told you I was bipolar? What does this have to do with abusing Maya? That's what I want to know.
Given how long Amaya has been placed in licensed foster care, why do you believe that your parental rights should not be terminated?
Okay, so here's the law. The law requires that I sign your document in order for my rights. Sign the document first and agree to participate in services. I did it. So you have no obligation to save my daughter from anything. You have an obligation to bring my daughter back to me because I never signed your documents. You can't even, right now this termination trial is unlawful. You can't terminate my rights unless I sign the document. It says it in RCW. There's no, even in the termination part, RCW, 1334-180, it says the same thing. I must have signed the document first. And okay, I've been offered services. That's only if I sign the document. I only have to do services if I sign the document. I never signed the document. Technically, she's been held hostage for almost 2.5 years. I've never signed anything. In order for you to keep my daughter in a foster home, I have to sign your dependency order, and I never signed it. That's why you guys hire lawyers to try to get them to sign it for me. And it's not happening. So whatever, right now, the foster parents have a document with my signature on it. That's fraud. That's forgery. And I'm going to go up there to Issaquah and get a copy of it, and then everybody's getting sued again.
Okay, hold on. Ms. Eyes, hold on 1 second. I have to close my door because there's a lawnmower outside. Hold on 1 second. When you say you have to sign a document, what document are you talking about?
The dependency order. I never signed it. So whatever you gave the foster parents is fraud. You gave them forgery is what you gave them. When I go up to the hospital and I get her medical records and I find out what you gave them, it's all over with. It's a wrap.
Now, we've discussed this in the past, though, and the fact is that your order for the order for dependency that related to you wasn't an agreed order. It followed a trial.
It followed a trial based on what? Perjury, right? Okay, great. So you already had the attendance records, didn't you? You got them on the 17th of March. You got them a day after she was taken away because it's the law for you to get them. under the law, under the shelter care hearing law, it says the school records and everything. So you've known from the day you've taken her that her attendance was perfect. You've known that there was no. I have the note that says from her principal saying that she did not act out in school ever, and you have it too. So you have no documented proof of her attendance. You have no documented proof of her acting out in class. All you have is hearsay from that teacher who lied, who Jenny Cowan got to lie, and that black lady got to lie. You know, they suborned perjury from that teacher, and that teacher got sued for it. And that's in exhibit number 70, I believe. You should read the entire thing. There's a link to it on her committing perjury in that thing. And I said right when she said it, I said, why did you lie? I knew she was lying right when she said it, and I called her out on it right away. I mean, I'm saying that was based on perjury. There's no child abuse finding. She was taken for risk only. Where's the child abuse? When was she abused? She was taken for risk only, right? You have to have a child abuse finding to even create a case plan. It's child welfare policy under the Adoption and Safe Families Act. The Adoption and Safe Families Act of 1997 requires a child abuse finding before you create a case plan. They can't even create a case plan. You know, follow the law. Try following the law sometime, you know? You know what the law is, don't you? You should try following it.
If at the end of this trial, the court decided not to terminate your parental rights, what would be different 6 months from now? How would things have changed?
She's probably still going to be in a foster home because you guys are going to keep her in a foster home, and you're going to appeal it and file again and file again and file again, and I'm going to keep suing everybody and their mother until the end of time, and including their mothers, because I know who all of their mothers are for giving birth to a kidnapper.
I'm sorry, whose mothers are you suing?
All of your mother and everybody else's mother. I'm going to sue all of their mothers. Yes. Biological mothers. Giving birth to a kidnapper. Yes.
You're going to sue my mom for giving birth to a kidnapper?
Yeah.
What will have changed in your situation in 6 months? Will you, if the court gives you, if the court denies the petition and now you have more time to try to get Maya returned to your care, what will you do to
exactly.
try to...
Yeah, that's exactly my point. Go ahead and finish the question.
Thank you. If the court denies the petition and doesn't terminate your rights over the course of the next 6 months, what will you do to try to have Amaya returned to your care?
I'm just going to keep suing everybody. I don't plan on doing anything different.
Why, if your prior lawsuits have been dismissed, why do you keep filing them?
I'm allowed to sue people for whatever reason when they violate my rights, no matter what reason it is. So like, let's say I sued them for committing perjury, which is what I did for the last one, right? Okay, so now they're doing something different. Now they're lying about this or doing something else. Then I could sue for that too. So it doesn't matter what they do. Each time I just keep suing for whatever reason I want to, really. Pick her up. Bring her here. I'll take her. I know she got chocolate cookies everywhere. Come here, pumpkins. I'm sorry, Mamacita. What's the matter with the baby? Oh, what's the matter with the baby? What's the baby? It's okay. It's okay. You want to say hi? You say hi.
Let me just follow up on that then. So I asked what you would do to try and get Amaya returned to your care, and you said keep suing everybody.
That's not what I'm doing to get Amaya returned to my care. I'm not going to do your services, okay? Just get that out of your head. I'm never going to do your services. But please stop asking if I'm going to do your services. I will never, ever, ever, ever. As a matter of fact, I'll go the opposite direction of your services. Your services are racist. You don't ask black people to do services. You don't. You're racist. So no, I'm not going to do your services. So stop asking. Yes, Mama. Here, Mama.
So I'm still trying to understand, how do you think that suing people is going to help you have Amaya returned to your care?
I don't. I just like taking people's jobs. I enjoy terminating people's jobs. That's what I enjoy doing. It doesn't look, I can see now that even when I did the services, you never tried to give her back to me. So why would I start now? When I did do what I was supposed to do, you said I didn't do it. So I'm going to be stupid and keep trying to do it, like, so you could say it again that I didn't do it? No, I'm not that stupid. I know what it is now. I see it for what it is. I see the racism. I see the hate. So I will not do what you want, and I will always sue the black people. And that's what I'm going to focus on. So that's going to be my number one goal, is to sue them. And if I don't care if they believe me or if you believe me, it's true. What's the matter, Mama? You got chocolate on your back.
Okay, I'm sorry.
Judge Adrienne Thomas McCoy, displeased with her presence on YouTube on November 13, 2024, along with Judge Janet Helson, who was the judge for the termination trial, terminated a mother's parental rights to her 10-year-old child. Initially, the judge issued a court order mandating the mother's arrest on August 29, 2024, if she did not remove the channel and all online content related to the hearings concerning her children. Following the mother's refusal to comply with the initial order, Judge McCoy proceeded to sign a second order. This subsequent order imposed a daily fine of $100 on the mother. The fine is intended to be in effect each day she continues to maintain the channel, persisting until she decides to remove it. To exacerbate the situation further, Judge McCoy has signed and upheld an order that prohibits any form of contact between this mother and her child. This order has been in effect for a total of 228 days as of today. This prolonged separation has undoubtedly added to the distressing circumstances surrounding the case, leaving the mother and child without any means of communication or connection during this extensive period. Judge McCoy has issued an order that prevents the mother from accessing the records of the termination trial. This decision is made despite the fact that the judge is aware the mother has no means to appeal what was discussed or decided during the trial if she cannot review the trial records. Despite these facts, the mother has proceeded to appeal the termination decision. The mother promptly filed an appeal, but Judge McCoy delayed submitting it until the last permissible day, the 30th day. This action appeared to be an attempt by Judge McCoy to cause stress to the mother. The case against the mother primarily relies on emails and communications from her, following Judge McCoy's intentional withholding of contact between the mother and her child. Judge McCoy seems intent on causing distress to the mother, as evidenced by the court orders. On any typical day when hearings are taking place in the courtroom presided over by Judge McCoy, it becomes evident that she tends to show favoritism towards specific individuals. This partiality is often apparent, whether it is based on race or Native American heritage. Her primary focus seems to be on the adoption of children, rather than on returning them to their families or original environments.
How is it possible that all of the officials who are involved in the hearings on this channel are upset about the channel's existence? Were they not fulfilling their responsibilities adequately? It seems contradictory for them to be upset when they are the ones responsible for the wrongdoing. It requires a significant amount of effort and manipulation to keep a child away from their parent. How have they succeeded in keeping this 9-year-old child separated from her mother entirely for a duration of 9 months? What specific narratives or explanations are they providing to her daughter to justify and normalize this situation? If they were the other parent, they might face arrest for a serious offense known as custodial interference. It seems that Judge Adrienne McCoy, Assistant Attorney General Catherine McCoy, along with attorneys David Hockendorf and Jenny Cowan, Brianna Johnston-Hanks, Bailiff Joy Stransky, AAG Latrice Tobin, Supervisor Julie DeCamp, and social worker Rachel Puga-Reynoso, take a disturbing pleasure in tormenting this child. These state officials persist in alienating her from the sole mother figure she has ever been familiar with.
Julie DeCamp is a supervisor at the Department of Children, Youth, and Families in Kent, Washington. She spends most days stalking white women for possession of their blue-eyed children, to force illegal child adoptions, under the wrong laws 100% of the time. Her boss is Shay Hopfoff, who is also obsessed with torturing indigent white parents. Their boss is Natalie Green, who is African American and hates both Julie and Shay, but uses them like puppets to carry out her revenge terrorism. Julie DeCamp is afraid of black people. Julie will do whatever they tell her to do, even commit crimes against extremely young children. Julie DeCamp will do anything to impress them. Julie DeCamp will kidnap 5-year-old children from their parents and keep them away from their parents for many months, not allowing any contact whatsoever. Julie DeCamp lives in Puyallup, Washington with her husband Mitchell DeCamp. They have been trying to produce a baby for many years and have been unsuccessful. Julie thinks she will one day be able to adopt a stolen blue-eyed child from DCYF. But Natalie Green told Julie she would have to put in way more work for that. Not only is Julie's career depressing to say the least, but the karma from her actions display in the form of poor reproductive health, as she has had no children yet. Julie DeCamp performs high crimes like kidnapping children for pay that is next to nothing, compared to most kidnappers who are compensated in the millions. Julie's services are a bargain for Natalie Green, who gets any child she wants while Julie gets sued back to back and Natalie hides behind her like a coward.
But I do notice that it's very important to a lot of people. Very important. And it's something that a lot of people have to have on every holiday, at a minimum on every holiday. So then why do you think it's okay for Child Protective Services to remove people's children for the possibility of being high when they approve getting drunk, and they don't take people's kids for it? They don't. I do not see CPS at the bar following parents home. So they don't. And all of their employees go to the bar every weekend and they don't take their kids and make them go to drug treatment before they get their kids back. I don't know who you guys think you're fooling, but you're not fooling me. That's ugly. That's like hypocrite big time. It's ugly, and it's like, who do you think I'm not going to say anything? Okay, so maybe I'm just realizing this, and that's really sad because I'm like old, and I should have realized this a long time ago. You guys have been playing people. CPS is a joke. They take people's children for the possibility of being high, not even being high, for the possibility, oh, you could get high, and what if you hurt your child? Bitch, I don't see you at the Mariners game. I want to see CPS at the fucking Mariners game, following parents home to remove their children from their fucking custody because they know they're drunk. Because I see 1,000 parents at the baseball games getting drunk. And then I see that goddamn moose, that Mariners moose, on fucking National Adoption Day, sitting there going gook gook yeah with the fucking foster parents who adopted a child because the child's parents were high. And they took their child and terminated their rights, but the fucking moose is pouring out fucking liquor, pouring it in their mouth. You know? That's sick. You guys are hypocrites. That moose needs to go. How are you going to be a gigantic distributor of alcohol and then go to National Adoption Day and kissy face with the fucking fosters that just stole someone's baby for being high or drunk? That don't make no sense. Hypocrite. You know? You don't deserve a dime. You shouldn't be supporting CPS if you're going to be serving liquor in your establishment. Because a drunk is high, it's all the same. So you're saying it's okay for people to get drunk and be drunk at all. I mean, I would trust a person that was on crack before I trust a person that was drunk with my child. So what makes you think that it's okay to remove a child for one, but not the other?
So your conversations with Ms. Diaz, were they about roughly an hour each?
Yes.
And did she make any other statements to you about her drug use?
You know, I would have to refresh my memory with my notes. I'm sorry. We did, as you said, we spoke about a total of 2 hours over the course of the 2 meetings. What I just recall being most impressed with is that she downplayed the significance of it and said that it basically didn't matter. She's gone back and forth with whether or not she will own use or not, so that changes depending on when you speak with her.
So would you say she takes responsibility for her drug use?
Absolutely not.
And have you, over the course of the trial, have you heard anything that has changed your opinion as reflected in your report to court that you believe dependency should be established?
No, I'm even more convinced that dependency should be established based on what I've heard and observed during this proceeding.
And can you give me examples of what you mean by based on what you've heard during the proceedings?
Well, sure. Just witnessing Ms. Diaz. So I'll start with what I have read and learned is that at the age of 18, Ms. Diaz began using. Then until present, my understanding of the document is that there has been a consistent problem in untreated mental health. There have been moments of sobriety and treatment, but in current day, we do not have documents that support that Ms. Diaz is clean and sober. She goes back and forth with saying she hasn't used, she's never used. I don't use. If I use, what difference does it make? Very, very concerning because I believe we have a mother with untreated mental health. untreated substance abuse, which then I find very complex and confusing. And this is not my role, but this is why I also support dependency, is that in this instance, I cannot determine whether, like, is her mental health a result of, or vice versa. Like, we know being used that, you know, brain cells deteriorate, people have delusions and hallucinations and all sorts of adverse side effects. But with Ms. Zayas, I don't know, but I do know that we have a mother with severe untreated mental health issues and what I believe to be untreated substance abuse. And she will speak about having provided us with discovery, but I believe some of those documents were fraudulent. They appeared to be created, form documents. There was significant information missing from them. Yes, the UA that Ms. Zayas provided on just recently on 9/17 was negative, but Ms. Zayas appears to be in a position where she needs to control the outcome of things. And so she is repeatedly, as she talks about the lack of a case plan, the fact that it's been offered, I too even asked her, Ms. Zayas, if you've done these things, like, are you willing to sign a release of information for me? Because we like to receive documents direct from the provider. I don't think I said in that moment, like, your documents look fraudulent, but that's what I was going for. I said, it's important that we have that information direct from the provider. But what she did instead was send me the same exact materials that had already been provided to the department. Again, when I asked about, are you in treatment or what are you doing? The only discovery that she produced were these Zoom emails that were from an individual that said in order to show verification, she needed to speak to what the topic of the group was, what it entailed, and whatnot. And I believe I looked through discovery intentionally, trying to find information to support that she was actually engaged. So I'm sorry, I feel like I'm kind of rambling, but I'm just trying to offer that if things are not done in the way that Ms. Zayas wants, then they don't get done. And I don't mean to discount her, but her unwillingness to understand the process of, we want to accept the material you've given us, we want to work with you, we want to see you get help, but the fact that you only want to do this a certain way, I'm sorry, like that, I can't trust what appears to be a fraudulent document. And being in this role, as long as I've been in this role, parents who are making progress, who are moving forward, they have their providers like reach out and they say, oh yes, this person is in compliance, they've attended meetings, they're doing really well. We receive reports, the department receives, and I too am.
And if I understood you correctly, your concern for Ms. Zayas meeting Maya's needs had to do with food, appropriate kinds of food. Is that correct?
That, yes. Mm-hmm.
And then there was one other, is it education?
Oh, homework.
Homework, okay. So other than choices of food and ability to assist with homework, did you observe any other deficiencies in Ms. Zayas meeting Amaya's needs during the time that you were together? I know you didn't see everything, but during the time that you were together. I'm not suggesting that you should have. I'm just want to make sure that I got it all. Mm-hmm.
Yeah, I'm just thinking. Mm-hmm. When I was asked that question, I responded that way because one of the things at the time was we were not going places besides the office. And so in the context of dealing with children and having them be out and playing outside and, being around other children or those types of things, I felt that was lacking also. So when she was asking me those type of questions, that I was referring to also that type of thing. but that did improve after I had spoken with her.
Okay.
That was one of the things.
And it was winter time, and I think you said there was some concern about Anya being cold if you were outside.
I think it was more in the spring, but
Oh, it was in the
because we had
spring.
had a couple of nights, we had a couple of nice days. Not every day, but you know, it's Washington, so yeah.
Okay. All right. Is there anything else you think that I should know?
But well, I don't know if it just goes by what I'm saying here or what's in my notes, but I will say
I don't
that,
have
you know,
your
it
notes.
is hard.
I don't have your notes.
Oh, okay. Okay. Yeah, that's why I have notes, though, because it's hard to remember everything off the top of my head. I guess there was one more thing that I don't think anyone asked me about, and that, except for Miriam brought it up, but for a different reason. But that was that I did call intake on her one time.
Okay. On Miriam.
On Miriam.
Okay. About what?
We were, I believe it was her car was broken down at the time she was taking the bus, and she did not have, it was raining that day when we were leaving the office, and we were at the Kent office, and it's very busy around there. There's, you know, 4 lanes plus a lot of times the middle lane and other roads, you know, it's very, very heavy traffic. And she made a comment that she was, she was not going to go in the crosswalk because somebody had been killed in the crosswalk a couple months ago. And she's pushing the stroller with Anya in it and going to catch the bus. And that was concerning because I didn't know if she was just being sarcastic or serious or whatever, but to think that she would try to zigzag through heavy traffic at that time was very scary. And especially, I drive a lot and there's just a lot of bad drivers out there, and it was just very concerning to me.
Did you observe her do that, or was it a comment that she made?
I did not observe her doing it. It was just a comment she made.
Okay. All right. Thank you very much, Ms. Davis.
By the time he gets done, I'm going to have 5 minutes and we got to go to lunch.
Well, if we have to call Ms. Bellamy back, we'll call Ms. Bellamy back. So let's get through this, okay?
No, that's not cool. I'm recording everything.
I'm sorry?
I said I'm recording everything.
Okay. So I am going to direct you not to record these proceedings. They are being...
What do you mean? You gotta be
well, hold on.
I can't buy the audio?
No.
I can't buy the audio?
You can get the audio from our clerk.
There you go.
So if you
then
want,
I'll have it.
Okay, so you'll get the audio from our clerk. Please turn off your recorder. Go ahead, Mr. LaRosse. I'm not going to limit anybody other than within the rules of evidence. So I don't want anybody to feel like they have to cut testimony short, because this is very important. And if we have to recess and resume, we'll recess and resume. I did that with my last termination trial, and it's fine. So nobody cut anything short on account of me. All right. Have a very good weekend. I will see everybody.
I don't give 5 fucks what they think or do. I have wasted way too much fucking time arguing with complete shitheads. I can't believe I ever complied in history. Fuck these judges, they have to go. There is no way I will ever shut my mouth. Now I see the problem and know that this agency never applied the laws properly from day one. It is my duty to expose them. My 21-year-old son wasted his entire life being traumatized by these fucking idiots. All of his court documents have laws made for abandoned juveniles on them. Basically, when you sign their court orders, you are abandoning your child. You are agreeing that your child should depend on the government. No such laws exist that allow this sorry-ass agency to force parents into rehabilitation and steal their kids until they can prove themselves. These people are kidnappers and domestic terrorists. But on a lighter note, the judges of the Supreme Court of Washington are allowed to interpret the laws as they see fit. While we understand that, here are the facts. The judges in all superior courts in the state of Washington have been applying a chapter of law RCW 13.34, which was created for abandoned juveniles, to abused and neglected infants. These judges are aware that there are no reunification statutes within these laws, resulting in parents being subjected to endless review hearings every 6 months, often presided over by corrupt judges like Adrian McCoy. These judges do not return the children because no law mandates that they do so. Furthermore, the Supreme Court judges have also added words to the law that do not appear in the original text, altering its meaning and exacerbating their abusive process. In Washington state, there is a specific chapter of law designed for the protection of juveniles, particularly abandoned ones. This is found in RCW 13.34.030(1). The law states that a child must be considered abandoned for at least 3 months before any legal petition related to their custody can be filed under this chapter. Importantly, Chapter 13 is the exclusive authority for juvenile court dealings. Today, we are going to clarify the legal landscape surrounding the actions of CPS, Child Protective Services, and how certain laws are being applied by Superior Court judges in all 39 counties of this state, often leading to confusion and misapplication. One significant issue arises with the misapplication of these laws. Superior Court judges are not permitted to cite RCW 26.44 within juvenile courts because the legislation does not empower them to do so. The laws are explicit. Courts must operate strictly within the written boundaries. Imagine you are a parent in Washington state. If CPS took your children without your consent to a court order from dependency or shelter care hearings, this could pose a legal issue, especially if you haven't agreed to any orders. According to RCW 13.34.130, the removal of a child from their home by DCYF, Department of Children, Youth, and Families, should only occur after the parent signs and agrees to the court order. Remember, signing any legal order is wholly within your rights to refuse. No parent should be coerced into agreeing to dependency. Now, a particularly troubling aspect is how the law addresses substance issues, specifically the mention of fentanyl. The statutes do not explicitly grant CPS the authority to remove children simply because a parent is using fentanyl. If the laws intended to allow such actions, they would be written clearly and distinctly to that effect. Hence, the mention in the statutes might be misleading, making it seem like CPS could intervene when legally, they may not have the grounds to do so. This situation underscores why every interaction with officials related to these matters should be recorded. Misconduct can occur, and having an accurate record of what transpired can be crucial for your legal protection. It is also vital to understand that many decisions might seem like they undergo a trial under RCW 13.34. However, legally, there should be no misconception. These are consent-based orders, typically agreed upon by all parties involved. In conclusion, as a parent, it's essential to be extremely cautious and informed about the legal processes involving your child. Never feel pressured to sign any documents without full understanding and legal advice. Remember, the law has to be very specific. If it isn't, CPS simply doesn't have the jurisdiction to proceed. We urge families to seek competent legal representation to navigate these challenging scenarios effectively. Your rights and the well-being of your child should always come first.
Examine myself, but
Well,
I guess I could explain a few things.
Yeah, I think so. The point, and it is awkward, and if we were in front of a jury, you'd have to be asking yourself questions. But because you're just in front of the court, you don't have to do that. But you do have to limit the topics to the things that Mr. LaRosse asked you, and that Ms. Cowan asked you. So if you want to address anything that they asked you, that would be the proper cross-examination.
I don't even remember what he asked for. Can you remind me what he asked me again? Because he asked me a lot, and I can't remember.
He did
exactly
ask you a lot, and I can't remind you of that.
Let me think.
But if you talk about something that he didn't ask you about, then he will object. So you can just go ahead, and then if Mr. LaRosse or Ms. Cowan thinks it's outside the scope of what they asked you, then they will object, and then I'll rule.
Okay. Well, I guess if I would have known the things that I know, it took a long time for me to get to this point of realization and trauma in my life to be able to know the things that are happening and how to deal with them. So even though I did what I did in the past as far as dependencies go, I did not know what was happening, the outside reasons. I did not know that, that there were other things going on. The stuff that I didn't know back then is the reason why I complied. And I didn't know a lot of things, and I didn't think I was allowed to not comply. I thought that I had to, because I thought that my rights would be terminated if I did not. And then they ended up, losing them regardless. So I didn't comply because I thought I needed help. As a matter of fact, I did treatment 3 times in 6 years, and I completed it. And then my social worker would go in the court and say I didn't do anything. So I kind of thought I was going crazy. And but the compliance wasn't because I wanted to comply or because I thought it would be good for me. It was because I thought I had to. So there was no desire to correct anything because I never abused my child. So it kind of was like a confusion and I guess feeling like a victim, and then just submitting, I guess. It wasn't no desire where I felt like I was going to be a productive member of society. I firmly believe that the only reason, I think that, there's a long story behind it, but that, drug addiction is a little bit overly, what do you call it? Dramatic by the family courts who desire to take children from people and sell them for funding or whatever. So it took a long time for me to get to that point. Like, if you would have asked me this when I was doing it, of course I thought I had to do it, so I did it. But at no point did I say, I'm going to do this because I know that if I don't do it, I'm going to hurt my children. That never crossed my mind. Usually there's, a lot of people in the world who have problems with mental health or problems with, going to the bar too much, or, and they don't have their children removed permanently from their care. That's dramatic. That's excessive, and that's, oh, somebody's calling someone on my phone. Who are you calling? Let me see. You can't call people, Mama. Come here. Hey. Keep on. You leave it alone? You don't touch it? Every time. Hold on. Hold on, baby. Hold on. Mama. There. Don't touch it now, okay? There it is. Anyway, I'm yeah, I guess for a long time, if it seemed like I was complying, it's because I was confused about what was happening, and I was traumatized by the events that happened. So a lot of the times I never read the court documents, and I just did what I was told because I thought I had to. But I didn't read the court documents because of the hurt and pain it caused to read them. And it's not because I whatever they think, but it's because every time I read them, I read about how, my other daughter was molested by her dad, And it was like, I told them not to do that. So it's like all the court documents had all that information. And then they said, you know, a lot of
Hold
things
on,
in there.
Ms. Zayas, hang on. There's Mr. LaRosse has an objection.
Objection to the statement her other daughter was molested by her dad.
It's in the court documents. You guys have them. I'll put it on there. It's fine. It happened in court. They talked about it in court. So I'm sure I could use it as evidence.
Okay. So I'll sustain the objection to hearsay for now. And Ms. Zayas, if you want to present that document, offer that document now, you can, or you can wait until your case. Would you like to offer it now?
Yeah, that's fine.
Okay.
I mean, I can get it and then put it on there. But I don't.
Okay, you don't have it up there right now?
No, but it's easy to get.
Okay,
I mean,
well,
I can get
why
it.
don't we move on, and I'll make a
Yeah.
note, and you can upload it over the lunch hour.
Okay. But, okay, so basically that was the reason why I didn't read the court documents or, I complied because I thought I had to, basically. So I was misled. And if I would have known back then that I had a choice, and if you think about it, really, when you sign a piece of paper, you can either sign or not sign. I mean, they're not going to force you to sign. But I never thought about that either. And so basically I was just misled and coerced into a lot of things that I should not have been. And there's certain things that people do and CPS might apply to their life. But I just, now that I'm past all that, and see it from the outside looking in and see the other people who also have, you know, issues with this agency, I just don't feel like any of the 15 plus years of, you know, existence in my life was warranted. And I don't like to just hang out with social workers all the time. And it seems like I've been doing that for almost 20 years. And I mean, as much as most people would be like, God, they would probably go nuts just from a knock at the door. But to think that I have to deal with these people every single day for years, it's that in itself is traumatizing. I mean, just from, you know, the little bit that people do hear about them, just imagine having to, you know, be a victim to that for that long. It changes a lot. I don't think that anyone should be surprised that I don't comply, because when I show you what I did comply with and the pettiness of it, it'll just make you wonder why, you know, why these people are still employed.
Anything else during this portion of cross-examination, Ms. Zayas?
How many pages can the document be?
There's no limit on the size, I don't think. Mr. Mason, are there any limits on the size of exhibits? No, there's no size limit on the size of exhibits.
All right.
So. Okay. All right. Okay. Any redirect, Mr. LaRosse?
No redirect, Your Honor.
All right. Any redirect, Ms. Cowan?
No, Your Honor. Thank you.
All right. So